if when the red lights come on, well. Yeah, it's on. Sure.
quorum being present, the Committee on Education and the Workforce will come to order. Good morning. I want to extend a warm welcome to our witnesses. Many have traveled from out of state to be here today. We appreciate the opportunity to hear your concerns on an important issue impacting America's small businesses and their employees. Small businesses are the driving force behind the American economy and the American dream. They employ millions of Americans, bring communities together, and provide services we rely on each and every day. So many individuals have achieved the American dream by owning a small business. One of the reasons we're the greatest, most prosperous nation in the history of the world is because of the opportunity for people to take a risk, start a small business, and achieve a lifetime of success. As a former small business owner, I understand the many challenges small companies face. It can be very difficult and costly for small businesses to get up and running. And once they do, they constantly face tough decisions as they try to hire workers, make a payroll, and keep their doors open. Through hard work and determination, many entrepreneurs have found their path to success through franchising, which often involves lower startup costs. Opportunities through franchising as well as contracting have empowered countless Americans to climb the economic ladder and obtain a better quality of life for their families. Today, there are 733,000 franchise establishments nationwide that support more than 7.6 million jobs. The entrepreneurial spirit of small businesses, when combined with the resources, infrastructure, and potential of America's most notable brands, has brought untold innovation and horsepower to the American economy and desperately needed jobs to communities across this country. Sadly, unelected bureaucrats who have never owned a business or made a payroll launched an unprecedented attack on these successful business models that so many rely on. It began when the National Labor Relations Board issued an extreme joint employer decision which distorted the definition of what it means to be an employer. Then the Obama administration took this radical new policy a step further, spreading it to other areas of federal labor law. The previous joint employer standard made sense. For two or more employers to be considered joint employers, they had to share direct control over the terms and conditions of employment, including hiring decisions, for example. This clear, straightforward test provided stability and certainty for job creators for decades. But now local employers face a complicated, confusing, and vague new standard that has threatened their independence and created an enormous amount of uncertainty. Two completely separate employers can be considered joint employers simply because they made a business agreement that indirectly or potentially impacts their employees' day-to-day responsibilities and working environment. For small franchisees, it means they could lose control over their businesses to larger companies. We've heard from many small business owners over the years who are concerned they could lose everything they've worked hard to build for themselves and their families. One Florida small business owner once warned this committee, quote, "Instead of being a small businessman, I would virtually overnight become a manager for a large company. I now find myself in the position that an unelected board in Washington, D.C. can just unilaterally determine that my American dream is over," end quote. Who could possibly gain from this attack on the American dream? We know it won't be American workers. According to the American Action Forum, the joint employer scheme could result in 1.7 million fewer jobs. Powerful special interest groups are the ones who stand to benefit. Desperate to reverse decades of decline in union membership, union bosses now have a new tool that makes it easier to unionize. For years, they've been trying to unionize multiple small businesses together in one organizing drive, and the joint employer scheme helps them do just that. It's time to put an end to this extreme and partisan policy that does nothing to help American workers and makes it harder for entrepreneurs to pursue their dreams. This committee has previously advanced legislation to protect small businesses and their employees by restoring the common sense definition of what it means to be an employer. With a new Congress and new administration, we have an opportunity to get the job done. Already the Trump administration has taken steps to provide regulatory certainty where they can. It is my hope that hearing firsthand accounts today of the job-crushing impact of the expanded joint employer standard will build new momentum here in Congress to find the solution Americans need. I look forward to hearing from our excellent panel of witnesses, some who have taken valuable time away from their jobs to be here. And with that, I yield to Ranking Member Scott for his opening remarks.
Thank you, Madam Chair. Madam Chair, in recent years, employers have been increasingly moving away from direct hiring of employees to using leased employees, perma-temps, and subcontracting as a means to reduce labor costs and shift liability. Approximately 3 million Americans are employed by temporary staffing agencies on any given day, performing work on behalf of a client company that directs the employee's work but does not write the employee's paycheck. Since the end of the recession in mid-2009, almost 1/5 of all job growth has been through temp agencies. Research has shown that consequences for workers employed in these arrangements are lower wages, fewer benefits, and less workplace safety. And what marks these arrangements is the control over employees' employment is increasingly held by more than one employer. Our labor and employment laws have long held that more than one entity can serve as an employer. This is true under the National Labor Relations Act, the Occupational Safety and Health Act, and the Fair Labor Standards Act. Without joint employer standards, contingent workers may have no remedies for unfair labor practices, safety violations, or wage theft. To find one or more entity jointly responsible under an employment or labor law requires a showing that two or more entities share the right to control the work. For example, under the Fair Labor Standards Act, the Fair Labor Standards Act was intended to have a very broad definition of employment and joint employment. Joint employment under the FLSA does not simply rely on common law control tests it took. It also looks at economic realities of a potential joint employment relationship. Having this standard under the FLSA ensures that workers are fully compensated for minimum wage and overtime for the hours they work. This standard, the same standard for over 50 years, ensures that employers can't get creative and try to avoid wage and hour requirements. While the Fair Labor Standards Act and the Migrant and Seasonal Agricultural Worker Protection Act have broad definitions of employer, the National Labor Relations Act and other statutes based on common law impose a narrower test to find joint employment. There was a torrent of misplaced criticism over the National Labor Relations Board's August 2015 decision in Browning-Ferris, where the NLRB held that the client employer, BFI, and the staffing agency, LeadPoint, were joint employers at a municipal waste recycling facility and therefore had joint duty to bargain with the Teamsters Union. In that case, BFI exercised both direct and indirect control over the employees of the staffing agency. Direct control included oversight of employees' production, time card submissions, setting line speed, and rejecting the hiring of any individual selected by the staffing agency. The reserved control included the contractual right to set maximum hourly pay that LeadPoint workers could earn. Of course, collective bargaining over wages would be a futile exercise if the party that controlled the wage level was not at the table. The BFI decision, the NLRB restated the common law test for an employer, as it was called for in the Taft-Hartley Act of 1947 by defining an employer as one who controls or has the right to control the terms and conditions of employment. This is the same test the NLRB applied in many cases prior to 1984, a period, I would note, in which franchising flourished. But starting in 1984 and continuing through 2002, the NLRB issued a series of decisions that narrowed the common law test, eventually limiting an employer to only those who exercised direct and immediate control over employment matters. newly expressed concern about redefining who is a joint employer seems quite selective. The Bush and Reagan-era boards redefined the standard, and the Obama-era board restored the traditional common law standard. The court in the BFI plainly stated that the decision did not address joint employer liability for franchisors. Yet, many of the criticism of the decision comes from franchisors like McDonald's, which was named as a joint employer in an unfair labor practice complaint, along with its franchisees 8 months prior to the BFI decision. In that case, it's still before an administrative law judge. Attacks against the common law standard used in BFI are cleverly masked as concern for protecting the independence of franchisees. In truth, the push to narrow joint employment standards protects franchisors at the expense of the franchisees. Last Congress, this committee reported legislation that purported to protect franchisees from franchisors taking over their business operations because of a concern about franchisors reducing potential joint liability. The bill misleadingly named the Protecting Local Business Opportunity Act limited joint employers to those who have actual, direct, and immediate control over employment matters. However, what we learned is that the bill actually insulated a franchisor from liability as a joint employer, leaving the franchisee solely on the hook for decisions exercised through the franchisor's indirect control. The bill should have been named the Franchisor Empowerment Act because it freed franchisors from liability as a joint employer while opening their door for franchisors to actually exercise more control over the franchisee's labor relations without any liability. The point was underscored in testimony from the committee from the last Congress by Professor Michael Harper, where he noted the FBI decision should help protect the decentralized franchise model by encouraging franchisors to continue to rely on independent franchisee control of employment decisions. Press reports indicate that the majority will introduce legislation to nix the NLRB's common law definition of joint employment under the NLRA and shield some employers from having to collectively bargain with workers. Apparently, the scope is yet to be determined, but according to press reports, the U.S. Chamber of Commerce is involved in drafting the proposal, and perhaps we might find more clarity here today. So I welcome our witnesses and want to thank them for taking time to prepare their testimony. I also want to express my appreciation for those who had to travel some distance to be with us today, and look forward to hearing from each of our witnesses. Thank you, and I yield back.
Thank you, Mr. Scott. Pursuant to Committee Rules 7C, all members will be permitted to submit written statements to be included in the permanent hearing record. Without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material referenced during the hearing to be submitted for the official hearing record. I now turn to introductions of our distinguished witnesses. Mr. Jerry Reese is the Director of Franchise Development at Dat Dog, a hot dog business, and is testifying on behalf of the Coalition to Save Local Businesses. Ms. Catherine Ruckelshaus is the General Counsel for the National Employment Law Project. Mr. Richard Heiser is Vice President in the Legal Department at FedEx Ground. Ms. Mary Kennedy Thompson is the Chief Operating Officer of Franchise Brands at Dwyer Group and is testifying on behalf of the International Franchise Association. Mr. Michael Harper is a professor at the Boston University School of Law. Mr. Roger King is the Senior Labor and Employment Counsel for the HR Policy Association. I will now ask our witnesses to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect the witnesses answered in the affirmative. Before I recognize each of you to provide your testimony, let me explain briefly our lighting system. We allow 5 minutes for each witness to provide testimony. When you begin, the light in front of you will turn green. When 1 minute is left, the light will turn yellow. At the 5-minute mark, the light will turn red, and you should wrap up your testimony. Members will each have 5 minutes to ask questions? Mr. Reese, I now recognize you for 5 minutes.
Good morning, Chairwoman Fox, Ranking Member Scott, and distinguished members of the committee. My name is Jerry Reese, and I am the Director of Franchise Development for the New Orleans-based Dat Dog franchise. And I'm truly honored to be here today and want to thank you for your invitation. Do we have any Dat Dog lovers here, by any chance? Mr. Byrne, thank you so much. And if you love Dat Dog or want to learn a little bit more about us, you can check us out this Friday at 8 p.m. on Ginormous Foods on the Food Network. And for those of you who really love New Orleans food, my great aunt Leah Chase, the queen of Creole cuisine, runs Dookie Chase and is a James Beard Lifetime Achievement Award winner. So New Orleans food really does run in my blood. Today I am here to speak on behalf of the Coalition to Save Local Businesses, which consists of thousands of small businesses throughout the United States that are truly confused and impeded by the inconsistent, expanding joint employer standard that has come out of Washington, D.C. We are seeking fairness and clarity on the new rules of the unlimited joint employer liability doctrine. Simply put, the question of when an employer should be held liable as a joint employer is an unsettled question of law, and Congress should settle it. That is why our coalition is calling upon Congress to return to the very successful traditional joint employer standard that helped businesses grow and succeed for decades. Dat Dog is the kind of neighborhood establishment that simply aims to put a smile on our guests' faces. Founded on Valentine's Day in 2011, we have built a one-of-a-kind New Orleans-style restaurant known for its quirky hot dog combinations with sausages made from crawfish, alligator, and duck. Dat Dog, however, is so much more than its food and drink offerings. We've quickly grown and evolved from a tiny hot dog stand into an honest-to-goodness community center. As with many locally owned businesses, philanthropic giving and social good are built into Dat Dog's DNA. We regularly host fundraising events on and off-site for causes of all kinds, including organizations related to animal welfare, at-risk youth, and education. We sponsor the Son of a Saint organization, which helps better the lives of young boys who have become fatherless due to incarceration, death, or abandonment of their own father. My colleagues at Dat Dog and I have spent countless hours doing everything with these fatherless boys on how to fish, play chess, and even shave. As Dat Dog's business flourished, our next logical step was to provide franchise opportunities to other enthusiasts. Today, I am Dat Dog's one-man franchising band, but we are hopeful that I will be able to expand our franchise team and have new hires soon. Through our franchise program, we are on track to add 28 units this year to our existing 4 corporate locations, with a 5th opening in Lafayette, Louisiana this summer. But as with any business that is fortunate enough to grow, we now face new risks. Joint employer is the most prominent risk on our minds. The most important part of our business's success rests in the hands of our wonderful and capable people. We rely on them each day. And of course, all of our restaurants are corporate-owned at this point, and we hire our own employees. As we begin to franchise, the most important aspect of my position as the Director of Franchise Development is in training future franchise owners and their wonderful and competent employees. But training is a great example of the confusion that lies in the joint employer issue. Franchise companies naturally want to pass along their expertise and experience to as many people as possible within their system. But now franchise brands are limited by only being able to train franchise employees if the training is deemed necessary to ensuring brand standards. Madam Chair, thanks to the mess created by the National Labor Relations Board, franchising is caught in an unworkable catch-22. On one hand, franchisors must impose a series of operational standards upon franchisees to maintain brand standards and consistency. But on the other hand, these fundamental operational standards have served as the basis for regulators to name franchisors as joint employers of their franchisees' employees. I believe, or at least I hope, that this new joint employer policy was never intended to affect franchising in the way that it has. But I am certain that Congress has the tools at its disposal to resolve this small business problem and provide all of us some certainty for the future. Our coalition to save local businesses needs Congress to enact legislation that clears up the basic question of what is an employer. I know that no one in this room wants to make it harder for businesses to grow and create jobs, provide livelihoods to our employees, and serve our neighbors. Chairwoman Fox, thank you for your leadership on behalf of local businesses around the country. Please help us continue to grow and serve our communities. I would be happy to answer any questions.
Thank you very much, Mr. Reese. Ms. Ruckelshaus, you're recognized for 5 minutes.
Thank you. Chair Fox and Ranking Member Scott and members of the committee, thank you for the opportunity to testify today. My name is Kathy Ruckelshaus, and I'm a general counsel at the National Employment Law Project. We're a nonprofit that for nearly 50 years has promoted policies and programs that create good jobs, strengthen upward mobility, enforce hard-won worker rights, and help unemployed workers regain their economic footing through improved benefits and services. At NELP, we set up a Who's the Boss project, specifically because low-wage workers face problems in their workplaces where they have more than one employer. Janitors, home care workers, construction drywallers, warehouse lumpers, and agricultural and garment workers, some placed by temp and staffing firms and some contracted out, multiple levels away from their boss, are the workers we see who aren't sure who their boss is and don't know who's responsible for the job conditions. We set up this project because we were spending more and more time trying to help these workers who too often were losing out on our basic standards: workers' compensation, unemployment insurance, fair pay, and organizing and health and safety safeguards. The corporations that engage contractors and then look the other way have a leg up on companies that play by the rules, resulting in a race to the bottom. This affects the quality of what should be middle-class jobs and that could stimulate our economy. I'm going to cover 3 primary topics in my testimony, and there's a lot more in my written testimony, and I'm happy to answer questions. First, I'm just going to quickly describe what joint employment is and why it's important. Second, I'm going to talk about the impacts of outsourcing without responsibility on job quality. And then I'm going to describe briefly what the Browning-Ferris decision actually said and means. So first, what is joint employment and why is it important? All joint employment means is that more than one entity can be responsible as an employer. There has to be a violation first before you have a joint employment determination. Congress included this concept in all of our labor and employment laws since they've been passed. That means that corporations, including franchises, have been operating under joint employment definitions since as early as the 1930s. There's a good reason why all of our labor and employment laws permit more than one employer, and that's because it improves compliance by ensuring that corporations don't outsource the responsibility for their workers. In contracted jobs, it's often the case that one employer is more established and larger with a greater ability to implement policies or workplace changes to ensure that protections are met. When this happens, recognizing that businesses are joint employers is essential to achieving protections for workers. A lack of accountability arises when there's more than one company involved in the work and none takes responsibility for the jobs. A company's decision to outsource using an intermediary or a temp or staffing company is completely proper and often ends up without scrutiny when companies contract with above-board companies. We don't ever hear about companies that contract out with companies that don't have violations. But workers should not be left holding the bag when labor violations or other problems arise and no company is willing to step up and take responsibility for the workplace protections. So what does happen in outsourced jobs? My testimony goes through a lot of data about how outsourcing using temp and staffing and other contracting is on the rise. Some industries like construction, garment, and agriculture have had this structure for a long time, but more and more we're seeing jobs that are outsourced in a lot of our growth sectors of the economy That includes home care, janitorial, delivery and logistics, warehousing and retail, and even in manufacturing, which has traditionally been a solid middle-class job. Workers in these jobs sometimes don't know who the boss is, the company that signs their paycheck or the one that sets the contract terms. And their ambiguous legal status is a factor that's driving lower wages and poorer working conditions in our economy. Subcontracted workers' wages suffer. Oh, I see I'm out of time. I can't give my examples in my testimony. I'll say quickly what the Browning-Ferris decision is. It was Browning-Ferris hired a staffing company, Lead Point, to bring 250 recycling workers onto Browning-Ferris's property to sort materials in Milpitas, California. When the workers decided to try to unionize, Lead Point, the staffing company, could not deliver what the workers wanted. It couldn't raise the wages without consent with BFI, according to the contract. It also couldn't change line speeds and other health and safety concerns. So the NLRB decided that Browning-Ferris needed to be around the table with its staffing company in order to bargain over the terms and conditions of employment. This is a pretty unremarkable decision, especially with the temp and staffing company.
Ms. Ruckelshaus, I'm going to have to ask you to end your testimony.
Okay, thank you. I appreciate the opportunity to speak, and I'm happy to answer questions for the committee. Thank you.
Mr. Heiser, you're recognized for 5 minutes.
Good morning. On behalf of the entire FedEx team, I want to thank Chairwoman Fox.
Please.
I'm sorry. Good morning. On behalf of the entire FedEx team, I want to thank Chairwoman Fox, Ranking Member Scott, and the rest of this committee for the opportunity to share FedEx's view on joint employment. FedEx has a vested interest in this important topic because its operating companies contract with other businesses throughout the United States. Beyond FedEx, it's hard to identify a business that does not contract with another company as a supplier or as a customer. Under today's standards, many businesses are at risk of being embroiled in protracted litigation or another company's labor dispute. The current state of federal joint employment law is a shifting patchwork that results in uncertainty, confusion, and unnecessary litigation. We urge Congress to move forward with a two-pronged legislative solution. First, a standardized definition of joint employment, and second, a statutory safe harbor for businesses that have vendor compliance programs. Here's the problem. Federal employment statutes provide no specific and certain joint employment definition. This has led to judge-made common law and shifting agency positions. Courts have filled the statutory gap with non-exhaustive multi-factor balancing tests. The exhibit we shared with the committee as part of my written testimony provides a pictorial representation of current joint employment tests under certain federal laws. By our count, and just looking at the NLRA, FLSA, and Title VII, there are at least 15 different joint employment standards when you count the circuit courts, regulations, and agency interpretations, and they change from time to time. Under the FLSA, there are at least 5 different multi-factor tests, including the circuit courts and a DOL regulation. A further illustration of joint employment complexity is the Fourth Circuit's recent decision in Salinas versus Commercial Interiors. The court traced the complicated history of joint employment law and ultimately concluded that, and I quote, "Courts have failed to develop a coherent test for determining whether entities constitute joint employers." Ironically, the court followed the same path as other courts and set forth yet another broad 6-factor test that is part of a 2-step framework. In another Fourth Circuit case, the defendants have pointed out that under this broad test, the federal government could be deemed to jointly employ its contractors' employees. As another example, Title VII has 6 different variations of multi-factor tests, plus the EEOC's own joint employment guidance. Further, the NLRB's Browning-Ferris decision is a significant expansion of joint employment under labor law based on indirect control and reserved authority. Today, we have too many tests that are overly complex and based on so many factors that any claim can be raised and any outcome defended. results that vary depending on where a company does business and where it is sued, and too much distracting and unproductive litigation, which burdens commerce and courts. Joint employment plays an important part in protecting workers, but the current reality is not productive. We think federal legislation is necessary to bring clarity, consistency, and a reasonable level of commercial predictability. A federal standard should be objective and simple. Joint employment should be triggered only when two employers directly determine certain statutorily identified terms and conditions of employment. And to promote and ensure legal compliance, a statutory safe harbor from joint employment liability should exist for businesses that proactively implement vendor compliance programs. Businesses that do the right thing to protect the public, workers, and their brands through vendor compliance programs should not pay a negative price by being found to be a joint employer. The bottom line is today's shifting patchwork of joint employment tests is untenable, and we respectfully recommend that this committee move forward with practical legislation to address this problem. Thank you.
Thank you, Mr. Heiser. Ms. Thompson, you're recognized for 5 minutes.
Good morning, Chairwoman Fox, Ranking Member Scott, and distinguished members of the committee. My name is Mary Kennedy Thompson, and I'm the Chief Operating Officer for the Dwar Group. I appear today on behalf of the International Franchise Association. IFA works to protect, enhance, and promote franchising for more than 733,000 franchises that support nearly 7.6 million jobs. I've spent more than 2 decades in franchising, both as a franchisee and a franchisor. I served 8 years in the Marine Corps, and when I returned home, I wanted to take control of my destiny. But I had no experience, and I knew I needed help. In 1994, I got my start as a franchisee in Cookies by Design. The franchise model empowered me to be a successful business owner. After being recruited to the Dwar Group headquarters, I served for 9 years as president of Mr. Rooter Plumbing. I am now the Chief Operating Officer of the Dwar Group, the holding company for 11 service-based franchise brands, such as Glass Doctor, Mr. Appliance, and Molly Maid. I help franchisees achieve their dreams by teaching the franchising system. We do not employ, hire, or fire our franchisees' employees. It is not the role of a franchisor to get between a franchisee and their employees. Franchising allows consumers to have a consistent experience at a trusted brand while also knowing the owner. Think nationally, act locally. We like to say that franchising allows you to be in business for yourself, but not by yourself. I've been on both sides of the relationship and can tell you that communication and trust are critical. We provide resources to help our franchisees grow. The franchisee-franchisor relationship has been deeply harmed by the new joint employer standards that have been developed under the NLRA, FLSA, and other statutes. From 1984 to 2015, franchises operated under the joint employer standard based on direct control. This standard allowed franchisors to provide valuable resources to franchisees while giving them the independence to conduct business. While the new standard created by the NLRB's August 2015 Browning-Ferris decision, any business with direct, indirect, or even a reserved right to control, whether exercised or not, may be considered a joint employer. To limit this liability risk, companies may be compelled to exercise more control over their franchises. Even worse, unlimited joint employment liability threatens the future of franchising in total. More confusing, other federal agencies have sought to capitalize on the NLRB's expanded joint employment definition. With the new joint employment liability standards developing under multiple federal statutes, the impact has already affected franchising. Dwar Group has been forced to back off in providing traditional support to franchisees. Out of fear, we'll be considered a joint employer. We consider our company an educational organization whose job it is to educate our franchisees in best practices. But the new joint employment standards have changed how we train, who we train, and have made it considerably harder for us to best support our franchisees. While the legal landscape becomes more complex, we've been pleased to see members of Congress from both parties recently support franchise business. In May, 13 congressional Democrats sent a letter to the NLRB asking for clarity in the Freshies development case. The NLRB released an advice memorandum stating that Freshie, a franchisor, was not a joint employer with one of its franchisees. 3 months later, the NLRB revised its joint employer standard for all businesses through its BFI decision, but certain advocates continued to reference the now obsolete Freshie memo. The letter asked 2 things. First, whether the Freshie memo can be used as a blueprint for all franchise systems, notwithstanding the joint employer standard established in the BFI decision, and 2, how much flexibility will franchisors have to enforce brand standards before they cross into forbidden areas of indirect, unexercised, or potential control? In a letter, NLRB's general counsel declined to answer either question and stated the memorandum speaks for itself and should read in light of subsequent developments, including the board's BFI decision. This type of bureaucratic confusion is challenging for small business owners. What's worse, the new joint employer standard has shaken the trusted relationship between the franchisee and franchisor. 20 years ago, I had no business experience, just a desire to run my own business. The support and resources I received from my franchisor made that dream possible. It's disappointing to see that kind of support I was giving being pulled away because of new and unfair standards. The confusion and uncertainty around joint employer is frustrating, but I'm optimistic. This hearing makes me hopeful that Congress can act to fix these standards. A permanent legislative fix is essential. We need a clear, common-sense definition of what constitutes joint employer. At Dwyer Group, we continue to live our mission to teach our principles and systems of personal and business success so that all people we touch live happier, more successful lives. The American in me believes all of you do too. Thank you for inviting me to be here today. I look forward to your questions.
Thank you, Ms. Thompson. Mr. Harper, you're recognized for 5 minutes.
Chairwoman Fox, Ranking Member Scott.
Could you turn on your mic, please?
Oh, did I not turn it on? There we go. Chairwoman Fox, Ranking Member Scott, members of the committee, I thank you for inviting me to testify today. The boundary lines for American employment law are not ambiguous. They have been set in a series of decisions by the United States Supreme Court based on the common law of agencies. These decisions of the United States Supreme Court should not be disturbed. The decisions both accurately follow legislative intent and provide lower courts and the federal executive adequate doctrine for the implementation of this intent. Any departure from this doctrine by the executive branch can be rebuffed and should be rebuffed easily by the federal courts, including, if necessary, by the Supreme Court. Selective congressional intervention would engender greater legal uncertainty, troublesome inconsistencies between statutory law and common law, and the erosion of protections for the American worker. Now, I understand many members of this committee have been convinced that the Labor Board's decision in BFI departs from common law doctrine articulated by the Supreme Court. I disagree with that assessment. The BFI decision not only was narrowly framed and based on the common law, but also could have been decided on its facts without a modification of board doctrine. But if I'm wrong about BFI, or the doctrine on which it is based, or if the board expands that doctrine further, we all, including the board, will be told by the federal judiciary that the board instead must comply with the Supreme Court's common law-based principles. With all due respect, I think this hearing is a reaction to a lobbyist-manufactured tempest in a teapot. I think you've gotten bad legal advice, Ms. Thompson, in drawing back your training. I make these assertions based on research I completed as a reporter for the American Law Institute's Restatement of Employment Law published in 2015. I was primarily responsible for drafting the chapter covering the definition of the employment relationship. I think I have a good understanding of the development of the common law definition of employment in the 19th and early 20th century to govern tort liability and its application as a defining boundary for employment statutes by the Supreme Court. I found in my research as reporter that the same common law analytic standards of legal authority to control and aligned rather than independent interests, alignment between employee duties and employer interests, apply to claims against multiple employers as well as claims against single employers for purposes of tort liability. Thus, federal courts, including the Supreme Court, have interpreted federal employment statutes to contemplate joint employment where the common law would do so. I found this to be true even under decisions so-called economic reality multi-factor tests used by the circuit courts under the Fair Labor Standards Act, I think these tests ultimately look to the same question. They're different, overly complicated tests, but they ultimately, I found, looked on the facts. You've got to look at facts of case, not just this abstract doctrine. And if you look at the facts, they ultimately ask the same question about independent versus aligned interest. In recognition of all this, the restatement of employment provides an employer may have two or more employers under the same common law standards governing the employment relationship with a single employer. As any lawyer should understand, the common law represents the developing and cumulative wisdom of generations of judges. The enactment of any legislation by this Congress is going to be using ambiguous terms like direct. What's direct? Or actual. What's actual? Or essential? Or what is the other word? Immediate. What do these terms mean? The courts have got to interpret these terms just as they have to interpret the common law. And the courts have to do it in the context of facts. A statute, and this is the rub here that concerns me, a statute ostensibly directed at joint employment could pose an especially great threat to employment law and American workers by compromising more generally the common law definition of the employment relationship. Such compromise is a threat because the same standards apply. And it could mean that workers not only would not be able to sue other employers when one is insolvent, but they couldn't sue either one because they're misclassified as independent contractors rather than employees. Legislation framed to address the BFI decision is not needed to protect franchisees or other small businesses. First, franchising and subcontracting have thrived during judicial application of the common law standard. They will continue to do so under that standard. And second, by the way, any dominant business, including a franchisor, concerned about liability, not about collective bargaining, but about liability, all they have to do is put an indemnification clause, hold harmless clause in their contract with the franchisee, and they will not be, and if any liability can be transferred back to the franchisee. No problem. That's what I would advise if I were their employee. Okay, I'm out of time. I would just say one last thing. Stick with the common law. Everybody can agree with the common law, you know? I mean, you don't agree with maybe whether BFI stuck with the common law, but if you stick with the common law and you tell the board and all these other agencies that they can't go beyond the common law, then we can all agree. Thank you.
Thank you, Mr. Harper. Mr. King, you're recognized for 5 minutes.
Thank you, Dr. Fox, Ranking Member Scott, distinguished members of this committee. Thank you for having me again to testify. I'm here in my capacity as the Senior Labor and Employment Counsel of the HR Policy Association. The association represents large business entities that have operations not only in this country but throughout the world. There are 380 members in our association, and they collectively employ more than 10 million employees. Part of my testimony today is based on the association's recent work report, Workforce 2020. Now, this report I think is quite interesting. I would commend it to the attention of the committee. It represents a very expansive undertaking of interviewing our members regarding what they see as the Workforce 2020 challenges. Now, with that said, let's get right to the heart of the issue. I agree with the professor that we ought to look at facts. Any good lawyer looks at facts. So I brought the BFI decision with me today. And what is missing in a lot of this discussion is what the regional director, the initial trial finder, if you will, under the National Labor Relations Board found. Let's look at the facts. The so-called subcontractor here, LeadPoint, had the sole responsibility to recruit, hire, counsel, discipline, review, evaluate, and terminate employees. Those are the facts. Further, both companies maintained separate human resources departments, separate supervision. LeadPoint at all times supervised the employees on the floor. BFI did not set wages, didn't administer benefits, and was completely separate. Now, I'll take those facts any day. And this case, of course, is pending before the D.C. Circuit Court of Appeals, and we shall see. But the problem with the BFI case is not just the decision of the board, which, by the way, the board in Washington overturns the finder of fact, the regional director, which in and of itself is illustrative. This is just not about BFI. What that decision did is put the seeds in our jurisprudence system of some very unfortunate and really difficult litigation. But let's go beyond BFI. As pointed out in earlier testimony, since BFI issued, there's over 400 unfair labor practice charges on a subcontractor joint employer theory in the NLRB alone. McDonald's, which is subject to, as noted, protracted litigation in this area, has had to go through over 100 days of hearing. Over 100 days of hearing, with hearing dates set well into 2018. You tell me what business in this country, particularly small independent businesses, should face that. Can't that money for the NLRB budget be spent better? I hope and think so. But let's get into this discussion, as the professor says, about common law. Well, I think his testimony is helpful, frankly, to the position of the employer community. On page 1 and also on page 4 of his testimony, he says that none of the federal statutes in the labor and employment area have any meaningful definition of employees and employers they cover and provide no definition of joint employer status. Case over. It seems to me right there. We don't have a definition. Now, what the professor and others are suggesting is that we use the common law. I remember as a first-year law school student, professor asking all of us to define the common law, and he would give us a passing grade for the entire year. No one ever achieved that in the 40 years plus of this professor's class. The common law is very illusory. It's not clear at all. In fact, in the area of the EEOC, we have a 15-factor test. You tell me how any business, large, small, whatever, can discern what that test means. The common law isn't agreed upon in the Fair Labor Standards Act area, but our 12th Circuit Court of Appeals. We just had that recent decision out of the 4th Circuit. There is no unanimity whatsoever in the common law. And all due respect, Professor, the common law doesn't help us here at all. It's put us in this area of protracted, difficult litigation. Can't this money be better spent by businesses and others for job creation, better benefits, and better wages? I think so. We can do better in this country than spending all these resources on this type of protracted litigation. Now, I want to talk just a bit about reaching across the aisle on legislation. I know that's difficult. I used to be a staff member on the Senate side in the Labor Committee. I know that's challenging. But this is an area where the only winners, frankly, ladies and gentlemen, are the trial attorneys, and all due respect, law professors who can write articles about this area. No one in the general population is being advanced in a positive way by this dispute over who is and who is not a joint employer. We could and should come together. Now, hopefully legislation will be introduced. In our testimony, we have specific recommendations for same. There can be give and take on that. But I think for those that disagree on what the common law says, or if the common law is applicable or not, are incumbent to come forward with their own proposal if they don't like what's being proposed on one side of this discussion. We need clarity in this area. We need for the business community, for employees and others, to be treated fairly with some degree of uniformity and predictability. My final point...
I need to ask you to wrap up.
Yes, I will.
You're way over your time.
I'll be happy to answer questions. Thank you, Dr. Fox.
Thank you very much. I'm trying to be fair to everybody. I will now recognize myself for 5 minutes, and I thank everyone again for your testimony. Ms. Thompson, Congress and the administration are interested in expanding opportunities to participate in apprenticeship programs. These programs are among the best ways for individuals to gain skills that are valuable in the workplace and increase pay. One of the concerns with an expanded joint employer standard is that it will discourage franchisors from offering apprenticeships or other skills development programs for employees of franchisees. Could you describe the apprenticeship or skill development programs your company's brands have offered, and have these programs been inhibited or curtailed by the expanding joint employer standard?
Thank you, Madam Chairwoman. One of our brands is Rainbow International, which is a restoration company, and we provide training in an apprenticeship program that is tied to earning certifications in mold remediation and other certifications within the insurance world. And for those employees of the franchisees that attend those certifications and get those certifications, they can actually grow in their career and earn a very good living, and more than $50,000 a year as they grow into these jobs. And the confusion around joint employer, not having clarity, consistency, and predictability is causing us to pull back on those programs. I said earlier that our mission is to teach our principal systems of personal and business success so that all people we touch live happier, more successful lives. We want to be able to provide those, but there's not a clarity in that. And so we're pulling back on some of those programs.
Thank you very much. Mr. Reese, I'd like to discuss why the franchise model is important for Dat Dog's future plans. I understand that your company seeks to bring a unique cultural and culinary experience to other markets by partnering with franchisees. How does the franchise model strike a good balance between everything your company represents as an ambassador of New Orleans and the independence of local franchisees? Would an expanded joint employer standard interfere with these efforts, and how so?
Thank you, Madam Chairwoman. We really are honest-to-God community centers. I talked a little bit in my testimony about our philanthropic endeavors, and that is a cornerstone of small business. And I'm very good at that in New Orleans. I don't think I would be as good at that in other places, and that's why I'd like to have franchisees in those places. I want Dat Dog to be that honest-to-God community center across the country. But with the joint employer standard and the way it is right now, I don't know what to train my people to do yet. I'm just starting out. I just sold my first 28 units about a month ago. So I've been told over the past year by consultants, people that I've met in the industry, if you do these things, if you train this way, you're going to be fine. But what I've learned over the past couple of months with the Coalition to Save Small Business and with the International Franchise Association is that even if I do what the spirit of franchising is, I still could be in legal hot water, and I don't have the funds. As Attorney King said in his testimony, I can't be in a hearing for 100+ days. It would kill my business before it even started. So some clarity and some definition would be helpful.
Thank you. Mr. Heiser, a company such as FedEx does business across the U.S. How has the presence of multiple joint employer standards under the FLSA and other federal laws negatively affected your business operations or the operation of your business vendors? Are employees potentially negatively impacted?
What I would say, Chairman Fox, is that as several of us have discussed, is that the current state of the law is simply a patchwork. There are many different tests applied by circuit courts, agencies, and they have been changing over the years. In all deference to my fellow panel member, while there is common law, certainly there's an opportunity here to bring greater clarity to the legal standard for joint employment through a statute of some sort. That would be our position.
Thank you very much. I now recognize Mr. Scott for 5 minutes. Again, thanks to the panelists.
Thank you, Madam Chair. Mr. Harper, I kind of perceive a difference in clarity and immunization. Can you tell me what restatement of the law is? Can you use your microphone?
Restatement of employment law is generated, as all restatements, by the American Law Institute, which is a organization of several thousand distinguished jurists, lawyers, and law professors that issue restatements of torts and contracts and agency and audit restatements. And this is the first restatement of employment law. and it covers a range of topics. The first chapter, on which I was a principal reporter, considers the definition of employment relationship offered by the common law.
But in the legal field, the restatement is generally viewed as the ultimate resource if you want to know what the law is. Is that right?
And if Mr. King wants a proposal for one statement of that, he can go to the Chapter 1 of the Restatement of Employment Law, because the American Law Institute articulated what all these tests are about.
Now, many of these proposals will immunize the franchisor from liability. Would it add any clarity?
I do not believe it will add clarity because, as I said, the words that will be used will have to be interpreted by the courts, and they'll be interpreted by the courts in different ways. What will happen, though, if words are used in legislation, and it's clear from the legislative history that Congress thinks that the courts have gone too far, they're going to cut back in protection not only of joint employment, but also of single employment, and that concerns me even more. And what Mr. King said, what Mr. Heiser said, indeed, Mr. Heiser's even presence here from FedEx, which is is concerned is not with joint employment, but with misclassification. My greater concern is this will lead to a contraction of single employment. So many American workers will not have anyone to whom they can look for minimum wage and maximum hour and unemployment and OSHA protection and ERISA protection. That's or anti-discrimination. That's my greater concern here, because if you say joint employment is unclear and we need to change that, the same argument can be applied, and the same statute will be arguably applied by the courts to single employment.
A question was made on maintaining brand quality. If you're maintaining brand quality, what does that have to do with joint employment?
There have never been cases that have argued that any effort to maintain brand quality makes someone a joint employer. These franchisors can insist on certain uniforms, they can insist on training, they can insist on background checks on employees, they can insist on certain kinds of service as part of what they're selling to maintain brand quality. That does not make them a joint employer, and if the board or any other executive agency made that move, the courts would rebuff them.
Now, if a franchisor, the question has been raised about the franchisees being taken over by the franchisors if we don't change the law. If we immunize the franchisor, would they be more or less likely to invade and control the franchisee?
Well, it seems to me that if I'm told that I can indirectly control by ordering my franchisees to do things, I guess that's indirect. I guess that's what indirect means. It's an ambiguous word. But if I can order them like a captain orders a sergeant to order the corporals and the privates, if I can do that, then I've got the best of both worlds. I can have control, and I can assert that control. So immunizing the franchisor, it seems to me, is just going to lead to more control of the franchisees and less independence for for these small business entrepreneurs. I think the argument works in the other direction, frankly, and the protection of entrepreneurship and small businesses works in the other direction, frankly.
Thank you, Mr. Scott. Mr. Thompson, you're recognized for 5 minutes.
Thank you, Chairwoman. Appreciate the members of the panel be here. I mean, franchise are so important. I don't see franchise as a matter of control, as more empowerment and helping individuals to pursue the American dream. Mr. Reese, I can tell you're very passionate about the Dat Dog brand. Looking forward to trying that. But also, you're obviously passionate about the business plan that you would roll out to your franchise, and I think the social enterprise, for lack of a better word, your mission with youth, and you're to be congratulated for that. You spoke of the plans to open more than 20 stores. Would this be possible for Dat Dog without the franchise model?
I don't believe so. I don't believe it would be possible financially, and I don't believe that the brand standard that we have of being stakeholders in our community, I don't think I can send people from New Orleans across the country and ask them to pick up another market and what it feels and what it needs like that. They know that about New Orleans. I need franchisees in those markets that come to New Orleans and visit their child at Tulane and say, wow, I really love this place. We need one of these in Washington, D.C. They care about people. So to answer your question directly, I don't believe it would be possible without the franchise business model.
Thank you. Ms. Thompson, thank you for your service to the country. And for coming to testify today. Does the franchise model give veterans an opportunity to be their own boss and start a business? And is that something that the Dwyer Group focuses on?
Thank you, Congressman.
Your microphone, please.
Thank you, Congressman. First of all, I would say it's my honor to serve our country. I try to also serve our franchisees as I served our country, and we have a wonderful program in the IFA called VetFran that works with franchisees who are veterans and bring them into small business ownership. We have more than 500 franchisor companies that work with these franchisees. In the Dwyer Group, we have brought in more than 300 veteran franchisees into small business ownership and have given more than $2.5 million in discounts to veterans coming into small business ownership. I believe that they've served our country and we owe them the power to prosper.
How would an expanding joint employer standard harm the ability of veterans to start a small business?
Well, there's a number of things that it would do. First of all, I have to go back to the uncertainty and the unclarity. When we don't know what the rules are, even if they're bad rules, we don't make decisions on growth. And what's happening is the franchising community is holding their breath right now because we don't know. Mr. Harper said that we had bad legal advice. We're getting legal advice from all over because there is not clarity on what that is. And so what happens is when the franchisor is thinking about how to grow, then they're not able to offer up as many opportunities to those veterans that are coming in. And I can speak from personal experience as a veteran. I was so grateful to have this system. I didn't know business. I didn't even know how to spell P&L. And to have that system to come in on and grow with and be able to have control of my own destiny, to hire who I wanted to hire when I wanted to hire, and to take the system that I got and apply it within my market, it made my life. It helped me create wealth for my family.
And I appreciate that. As the father of an Army Staff Sergeant who is proudly serving, and my guess is will continue to serve, but he has thought about what-if plans if he was to leave the service, and quite frankly, looking at franchise opportunity as one of those because of the empowerment, that support network of, to be able to enter in that. And I'd be concerned with anything that would, that would hinder that for all of our American heroes that are serving, and at some point will transition to civilian life. Mr. Heiser, under a joint employer standard such as the one in BFI, FedEx may be liable for unfair labor practices or other violations by the vendors with which it does business. Does FedEx have any way to police the employment actions of vendors, and how will the expanded joint employer standard affect the contracting you do?
Right, so expanding the joint employment test obviously is going to create uncertainty in the business community and the franchising community. And circling back to your question about partnering with vendors to ensure that they're compliant, that's the reason we're proposing that there be a safe harbor of some sort for businesses that proactively have compliance programs for their vendors. That ensures that our vendors are doing the right thing, that they are treating their employees appropriately. And what we believe is that if a business knows that they're being checked on by their customer, they're more likely to comply with the law.
Thank you. Thank you, Chairwoman.
Thank you, Mr. Thompson. Ms. Davis, you're recognized for 5 minutes.
Thank you, Madam Chair. Thank you, all of you, for being here. Ms. Ricklehouse, if you may not recall exactly where you stopped, but I wondered if you could go back to your final comments quickly and try and clarify what you wanted to present, because I'm looking to the impact that you're seeing, and if we're able to come to an agreement, I'm almost ready to ask everybody what their own definition would be in this instance. But could you go back to that quickly and sum that up so that we have a little more clarity about where you wanted to go?
Yes, thank you, and I apologize for going over. I should have practiced more with my testimony. I was going to give a couple of concrete examples of where joint employment is direly needed, and when workers don't know who their bosses are, but there are violations and there needs to be compliance assistance. So we helped some auto parts workers in Canton, Mississippi, who wanted to work at a local Nissan plant. They were told, you go over there, get hired by the staffing company, which they did. They then went to the plant and started working. They were exposed to hazardous chemicals. They weren't paid properly, and they decided they wanted to try to fix the problem. The Nissan plant said, we are not responsible for health and safety training or your wages, and the staffing company didn't know what to do about it. So both companies essentially told the workers, we don't know, talk to the other one, and the workers were left without any recourse. So that's one example, and nobody thinks that's a good idea. I think we would all agree that shouldn't happen. Another one is corn detasselers, a case that we worked on in Indiana where the corn workers, they were roguing and detasseling the corn. They were hired by a farm labor contractor who went out of business. They weren't paid properly. They actually got paid less than minimum wage. And when they went to the seed company, which controlled the property and the work, the seed company said, it's not my problem. So again, these were workers where everyone agreed they weren't paid properly. They needed to get paid the minimum wage, which is $7.25 an hour federally, and one company disappeared and the other one said it wasn't my problem. So I just wanted to give those two examples. I have a million of them, but this is where joint employment is required, and I've never in my practice heard of any franchise ever been held to be a joint employer under the Fair Labor Standards Act, which has since the 1930s been the broadest definition of who's an employer. So I think a lot of the concerns that we're hearing here are very hypothetical. They haven't happened, and I think we don't want the good examples here of franchises who want to train, who want to do right by their workers. They shouldn't be impacted by any discussions of joint employment responsibility.
Yeah. And I'm wondering then, going back to I guess it was, let's see, where are you, from Dodge.
Mr. Reese.
Yes, Mr. Reese. You were talking, I think, about the branding, that you weren't allowed to do anything much beyond branding in terms
Beyond
of
brand standards, yes, ma'am.
Beyond brand standards. So where did you get that information from?
We did franchising the right way. When we decided we wanted to franchise, we made sure we got consultants, we got attorneys that had been doing franchising work for decades. And they told us very clearly what the spirit of franchising was, and if we trained the trainers a certain way, they would then train their employees and we could ensure brand standards. But now the trainer is that training the franchisee's employees, and then the line gets blurry very quickly and there is no definition. So we just want to make sure that we are training people the right way and that our brand is, when it grows, it's grown properly. But right now, we don't know where that line is, and that's what we're asking for some help with.
Mm-hmm. And within all of you, I mean, what does that say to you in terms of where you think the line should be? Because I think, Mr. Harper, you're saying that it's pretty clear. I'm sorry, I just asked Mr. Harper just if he respond.
Yeah,
I'll get back to you, sir.
The Supreme Court has said not only that the common law should apply to all these statutes, but has articulated a test under the common law, a several-factor test, and if the Title VII courts are not using that test, they're not complying with the Supreme Court. If an OSHA board is not using that test, they're not complying with the Supreme Court. If the National Labor Relations Board is not, it's not complying with the Supreme Court. So the Supreme Court has said in the first in Reed and they confirmed in the Darden decision, which cited my testimony, what the common law test is. It is a multi-factor test that they articulated, but it's not many multi-factor tests. It's a particular multi-factor test.
Would you agree that this needs another look? Do you think it needs another look, or are you saying we got it?
Well, I think that there is a big push from the majority here for legislation, and particularly to protect the franchisees. Training programs.
Mr. Harper, I think you have to answer the question very quickly.
Okay.
Very quickly, 5 seconds.
I think it's better to maybe have some safe harbors for the franchisee than to mess with the common law generally. That's what I was going to say.
Thank you.
Thank you. Mr. Wahlberg, you're recognized for 5 minutes.
Thank you, Madam Chairman, and thank you for holding this hearing. This is, it's frustrating to a degree that the genius of this great country, especially economically, has always been to encourage entrepreneurship, encourage individuals to take risks for rewards as well as some of the failures that go on. But nonetheless, to make it as easy as possible without having to have a law degree. Ms. Thompson, I hope you get some credit for the instruction you received there at the table from the professor. It certainly would be worth your time to at least get the credit hours. But it is frustrating that when under the guise of trying to protect individuals, the little guys, we're making it more restrictive for the little guys, the entrepreneurs, to be successful. And so I appreciate this hearing because we need to talk about this more. It isn't that simple. When we talk with franchisees out there, we talk with this joint employer issue, it is as muddy as can be. And it's restricting, it's chilling the opportunities to get that economic generator in a unique period of time in our history moving again rapidly with all of the amazing ideas, some of which we saw on our recent trip. The sharing economy, the enterprise that's going on, and certainly franchisee. Ms. Thompson, in your testimony, you stated that franchising has been harmed by the new joint employer standards that have developed under the NLRI and FLSA. What statutes are your biggest concerns with regard to joint liability?
Congressman, what we really think about is the confusion from when the BFI put their statement out, compared with everyone keeps going back to the Freshie offer and saying, well, this points back to what we have. It doesn't point back because it was an informal guidance, and then it was made obsolete by the Browning-Ferris decision. And so what concerns us is the customer experience, how the customer is going to experience our brand and what that means to how we train our franchisees and how we train and make sure that, to go back to what Mr. Reese said, the train the trainer. When we say that it hasn't affected us and it doesn't affect brand standards, I beg to differ. I would say that if we have to tell an employee how exactly to clean a bathroom, we don't do that in Mr. Rooter because we don't have bathrooms and public bathrooms in the Mr. Rooters, so we don't train to that because it's not part of the customer experience. But in another company where you go in a restaurant, it's part of the experience, we need to be able to do that training and not be in this environment where we don't know if we consider it a joint employer or not from that.
Okay. Ms. Thompson, as well as Mr. Reese, what does legal uncertainty mean when you're running a business?
It means slow growth. It means big companies will tighten down and batten down, and small companies will have a much harder time growing, and the entrepreneurial spirit will dim.
Mr. Reese?
I'm worried about my business not getting off its feet before it starts, or getting off its feet and being hit with a joint employer liability suit and it stopping. I mean, I get, we have lawsuits out there with big companies. I have 28 signed units, 0 open. I am very much a small business. I get the franchisee being the little guy and the franchisor being the big. I'm still the little guy here, and so I want to make sure that there's some sort of clarity there so that I can grow my business and bring these community centers and restaurants across the country.
Okay. So it really acts as an anchor, a weight.
It's a huge weight, and
back.
when you've been told or when you have studied or you've educated yourself about franchising, this was my first job. I was still in college when I started working at this place. I was scrubbing the floors and grilling the hot dogs myself. So I get it, you know, and I'm worried that I'm looking at people coming to me for franchise opportunities and people wanting to be on my team and seeing how awesome it is that we've sold so many units so quickly, but me not sure how to train the franchisee and also how to train the people on my staff to make sure when they're talking to people, they're not getting in joint employer hot water. So it's a huge weight on franchising shoulders.
Yeah. Well, thank you for taking the challenge, and we hope we can assist it and make it that this is your dream as opposed to a nightmare in working with.
Thank you, Mr. Wahlberg. Ms. Fudge, you're recognized
I yield back.
for 5 minutes.
Thank you very much, Madam Chairman, and thank you all for being here today. You know, I've heard my colleagues ask a lot of questions, and I've heard very little specifics, probably because there is no uncertainty. We don't really need to talk about it anymore. We just need to follow the law, whether we like it or not. What I hear is you don't like it. It's not uncertain. Ms. Ruckelshaus, you talk about the Browning-Ferris decision and the fact that it returned the joint employer standard to the pre-1984 standard. Is there any evidence that the pre-84 standard or the return to the standard has hindered the growth of the franchise model?
No, there's no evidence, and we've heard today from several witnesses that there's over 733,000 franchises with millions and millions of workers. So there is no evidence that these standards have impeded growth. And what I'm really struck by in the testimony is that there seems to be a fear of being an employer, and I don't understand what that fear is, because I think it's just an interesting discussion about not wanting to have employees, not wanting to be an employer. It used to be a great thing to be an employer in this country, and I don't understand that. And obviously my practice is not about franchising. We've never heard any problems in franchising. These sound like great companies. We have other problems to solve for low-wage outsourced workers who need to have more than one employer. So I'm concerned about the direction of the discussion.
It just sounds to me like they just don't want the responsibility. But beyond that, second question to you, Ms. Ruckelshaus.
Congressman, if I may, there's no fear about being an employer.
No, you may not.
Right.
I'm asking the questions. Ms. Ruckelshaus. The purpose of the NLRA is to promote workers and the right of workers to collectively bargain. That is what it is intended to do. Do you believe that the ability for workers to collectively bargain and fight for higher wages and improve workplace standards are bolstered by the NLRB's Ferris decision?
Yes, I do, because this is, again, a temp and staffing firm that brought 240 workers onto a recycling site. Now, if those workers wanted to come together and bargain, they need to be able to sit down with the companies that have the ability to deliver what the workers are asking for. So a temp and staffing firm, it's fine to use those, but it may mean that you also have to sit down with them. It's critically important that the players that have the ability to comply with the law or to bargain with workers be around the table, and they shouldn't be able to hide behind staffing companies or temp firms just because they don't want to do that. It's just not proper.
Thank you. My last question to you. From your experience, just where do you see that there really is room for improvements in the NLRA, the FLSA, or OSHA, so that Congress can really take some positive and steps that really make some sense so that we can better serve the people we've been sent here to serve?
There's some great examples in state laws where joint employment has been solidified to say it takes the employment question completely out of the equation. In California, there is a law now that says if you're a contracting company, if you use a temp or staffing firm, if you use a subcontractor, you're jointly and severally liable for minimum wage and workers' comp. You don't have to show employment relationship. You can do whatever you want, but you're jointly responsible. And all that means is if there's a violation, both companies are responsible. Oftentimes there aren't violations, and so we don't hear about these. But California has passed that. Illinois has a temp worker Bill of Rights that does the same thing, that says if you use a temp or staffing firm, you're jointly responsible along with that firm for the workers that you've contracted with. Those kind of laws are they're gap fillers, they're clear, and there's no question about are you an employer or not. It's just if you decide to contract out, you're still going to be responsible for those workers if there's a problem.
Thank you very much. Madam Chair, I yield back.
Thank you, Ms. Fudge. Mr. Wilson, you're recognized for 5 minutes.
Thank you, Chairwoman Fox, for your leadership on this issue, and what extraordinary witnesses to have here today. Thank you very, very much. And Ms. Thompson, I want to thank you for your service to our country. Congratulations on your success as the first female platoon commander of your unit. As a really grateful dad of 4 sons in the military and a veteran myself, I'm really proud of your service. As a franchise owner and someone who wants to assist others in assisting their franchises, will you provide greater insight into how the joint employer has affected your operations and decision-making? What have you done due to the joint employer that otherwise would not have been done?
Thank you, Congressman. I would like to just say we're not afraid to be an employer. We are an employer because we have, in our group, we have over 600 employees in our headquarters, but we're not the employer of our franchisees' employees. We don't want to be in the middle of that relationship, nor does the franchisee want us to be in the middle of that relationship. They want to be able to hire and fire who they wish without our interference on that. Something as simple as job descriptions. You think about, we have a service technician job, and all of our franchisees across all of the United States are hiring that same position. And in years past, we could just, let's put together this job description, let's bring a group of franchisees together, make sure we're clear on it, and let's send it out. With the unclarity and the confusion around joint employer right now, that became a year-long project. We had to consult with attorneys. We had to ask, can we really do this? Does this make us a joint employer? Because we're helping our franchisees with the system of just finding the best person possible, as a small example. Something that would have taken us an hour to do took us months and months to get done. And it continues, it just gets worse over time as to what's happening with that.
Well, thank you for your real-world interpretation. It's really sad that frequently here in Washington, it's like a parallel universe. And so thank you for being real. That is so helpful. Mr. King, according to the American Action Forum, the new joint employer standard could result in 1.7 million fewer jobs. 17 states, and I'm very grateful one of those is South Carolina, have taken action to protect small businesses from the impact of the standard. Given the impact of the rule, would you interpret that the new joint employer standard is a simple reinterpretation of the National Labor Relations Act, NLRA?
Please turn your microphone.
We have a very long ways to go. The American Restatement of Law the professor mentioned is a survey of the law. Those professors, those practitioners don't make the law. The study that you mentioned is a very real study. This is a concern, and it's hurting employees. That's something that hasn't really been brought out so far this morning. The state of the law today is hurting employees, and let me explain why. Because employees are not permitted of a subcontractor supplier to have the benefit of training, and I disagree with the professor about the brand quality issue is, in fact, part of the McDonald's case because the way you control brand quality is through supervision, through standards, et cetera. So we have a disagreement on that. But back to your point, the state of the law, but for some states, like as you mentioned, giving us some clarity, is in a total state of disarray, and it's hurting employees and employers alike. This is an issue that needs to be addressed.
Well, thank you again for being real, and that's why I appreciate Chairwoman Fox's leadership on bringing the issues to the American people. Mr. Heiser, thank you for taking time to be here today. Under the joint employer standards, such as the one for Browning-Ferris, FedEx may be liable for unfair labor practices or other violations by vendors which it does business. Does FedEx have any way to police the employment actions of vendors? How will the expanded joint employer standard affect the contracting that you do?
Congressman, that is why we have proposed in the legislation that we protect workers through vendor compliance programs. We're very concerned that any efforts by employers to monitor the compliance of their vendors will be used as evidence of joint employment in any litigation or unfair labor practice charges.
Well, again, we're just grateful for each of you being here and look forward to working under the leadership of our Chairwoman Virginia Fox for positive change. Thank you.
Thank you, Mr. Wilson. Mr. Polis, you're recognized for 5 minutes.
Thank you, Chairwoman Fox and Ranking Member Scott, for holding this hearing. Now, according to the title of the hearing, it's about job creation and entrepreneurship. But instead, we're doing same old tired attacks on the NLRB. I was a job creator and entrepreneur. That's what I did before I came here. Never had any issues with the NLRB. Outside of policy in my professional work as having founded or co-founded over a dozen companies, I don't even think I knew what NLRB was. I only knew about it from a policy perspective. It never stopped me from doing anything, never helped me do anything. Some of those companies went on to employ hundreds of people, others went out of business. So it just, in no way, it is this hearing kind of actually talking about the real issue of job creation and entrepreneurship. If we want to talk about how to make the economy work for everyone and support entrepreneurs and their employees, we should empower our employees by helping to give them a stake in businesses. My bill, the Work Act, would do that by helping promote employee ownership as a business structure. Employee ownership helps create stable businesses that support their community, aligns the incentives of workers and investors. Most of the companies that I started included employee ownership through stock options. Companies that are employee-owned, the facts show, tend to grow faster or more financially stable over time. And the Work Act would help employees and employers learn about how to transition to employee ownership and provide technical assistance. In Congress, we should be using our roles to shine a spotlight on the good work of entrepreneurship and startups across the country. Every year, Congressman Darrell Issa and I lead Startup Day Across America, an initiative where members of Congress visit startups in their district. We had over 30 members of Congress participate last year. I invite my colleagues on this committee to join Representative Issa and I, and we will help connect you with the startup in your district to visit in August. If we want to talk about job creation, I hope that we can talk about get to know folks in our district who are really creating jobs in the startup economy. Today's garage startup might be tomorrow's 1,000-person company, and that's what's so exciting about the dynamism of our country. My first question is for Ms. Ruckelshaus. Speaking of job creation, your testimony states that there's a myth that joint employment somehow spells the demise of franchising or small business growth. Can you briefly elaborate on why that's a complete myth?
Mainly because there hasn't been a showing at all that since these statutes have been in the books, and again, it's been since as early as the 1930s, that there's been any decline or cutting back on entrepreneurialism or franchising. We have heard from these witnesses that franchising is flourishing, and it's a strong business model. So the statutes have been on the books, the definitions of employer have been on the books. There's nothing new that is changing now that should spell the demise of franchising or any other kind of contracting for that matter.
And, in Mr. King's testimony, he criticizes the way that joint employer decisions under FLSA evolved in federal courts, and he proposes a one-size-fits-all standard. That sounds like a great idea to have a standard that you can apply, it's objective and simple. Can you elaborate on why we need a more flexible standard to actually determine the economic realities of each employment situation rather than a one-size-fits-all?
Yeah, I mean, I think we're hearing it today. You know, the descriptions of the businesses on this panel are very different than the businesses we see. And when I'm trying to enforce the Minimum Wage Act or helping workers get OSHA protections, every business and the relationship that they have with their contractors are very different. Some are two different separate businesses with above-board operations. Some are hiding, some contractors are hiding behind their undercapitalized labor brokers who don't take any responsibility. So you need a fact-specific test that looks at the realities of the relationship and the economics between how those operations are working.
Would you say that this reality is too complicated for a one-size-fits-all standard to work in this world?
It is. It doesn't work. The common law that Professor Harper has described has been around, again, since the Supreme Court has been around in the court systems in this country, and we need that kind of organic development of the law so that people understand it as it develops. And that's really how businesses have been operating since our country has been established.
And I'll give the final word to Mr. Harper. You mentioned that congressional intervention could create greater legal uncertainty. And could you briefly address what legal uncertainties could be created and what some of the unintended consequences would be?
Well, for one thing I want to stress is you change joint employment with these new words. It can affect in the courts what single employment could be. Is it going to affect misclassification and single employment? Those words have not been interpreted. Any words used in the statute, what they mean will not be clear, and how far the courts are to cut back on the definition of employment will not be clear.
Thank you, and I yield back.
Thank you, Mr. Polis. Mr. Byrne, you're recognized for 5 minutes.
Thank you, Mr. Chairman. And if I could, I'd like to offer for the record a letter dated May 8, 2017 to Mr. Barry Kinney, the Associate General Counsel with the National Relations Board, sent by 13 of our Democratic colleagues, in which they say uncertainty remains as to whether businesses may rely on the Freshie guidance because the memorandum appear fact-specific to Freshie's circumstances, and the NLRB's new joint employer test outlined in Browning-Ferris created a new standard for all businesses, including franchise businesses. I'll offer that for the record.
Without objection.
I have some questions, now that we've gotten some members of Congress from the Democratic side to say that there is uncertainty here. I have some questions for the two of you that have to deal with it. Not from a lawyer's perspective, not from a congressional perspective, but from the perspectives of somebody that's running a business and employing people and paying wages. Now, we've heard some talk here today that expanding the joint employer standard does not pose a real threat to the franchise industry. And the concerns we've heard here today are just part of an artificial special interest conspiracy. Indeed, Professor Harper's testimony claims that anxiety has been generated by lobbyists and lawyers looking for fees, not by any actual contraction of franchises, and that this hearing is in reaction to a lobbyist manufactured tempest in a teapot. Now, I'm going to ask the two of you who actually have to deal with this every day, is this a real issue or is it not? Is this just a tempest in a teapot? Mr. Reese, you first.
Sure. This is 100% a real issue. I'm just getting started, so I haven't crossed this bridge yet with my franchisees, and I'm very well aware of that. But I am also very well aware of the money that my company has put up with the 145 employees that we have now. And the money that it costs to start a franchise business the right way. It is very costly. And we're talking about adding a potential amount of dollars for litigation down the road because we don't know what's going on. We don't have, as you just stated in that letter, we don't have clarity. And so for somebody that's operating a business and still doing payroll, and we're a small business, we don't have a huge corporate office. I'm very much still in the day-to-day. It's a huge issue and a threat to our growth, and I really hope that we can just get some clarity on this.
Thank you. Ms. Thompson, you want to speak to that briefly?
Yes, Congressman Byrne. I would say I didn't know what the NLRB was when I was a franchisee either because they weren't messing in my business. But something that was suggested here earlier, that we could just have an indemnification agreement, there's all kinds of problems with that. First of all, it would drive a wedge between me and my franchisee that I don't want to do, because by the very nature, it would create mistrust and suspicion, especially around an issue as core and as important as the employer-employee relationship. And then those agreements, they give the opportunity for a lawsuit inside a lawsuit, because if the provision's been reached, no one knows what the remedy is. And then by including such a clause, the plaintiff's lawyer would have an additional incentive to sue both entities, exacerbating the joint liability risk. And let's talk about what it would do to my EPLI insurance rates and how it would increase our rates. And then lastly, as I've said in my testimony, I shared that the unlimited joint employer standards have deeply harmed our franchisor-franchisee relationship. What Mr. Harper suggests would only make things worse. What we're looking for is clarity so that we can do business.
Thank you. I may make this observation, Madam Chairman, if I may. Every time we pass a statute, that changes the common law. When we pass the National Labor Relations Act, we change the common law. When we pass the Wage and Hour Law, we change the common law. And when regulators interpret the statutory law, the Supreme Court gives them deference under the Chevron decision.
Right.
So if we don't have statutory law, we don't have clarity because we have this agency saying one thing and that agency saying something different. And it is the province of the legislative branch of this government to set the law of America, not the courts. So this idea that we should defer to the Supreme Court and common law is ridiculous. And anybody who's practiced law, not taught law school, practiced law, understands that. Because we have to deal with it every day, the real world application of it. And these two people who actually have to deal with it when they employ people, they're telling us this is a problem. So I think it's incumbent upon us as the legislative branch to do our jobs and make the law for them. And I yield back.
Thank you, Mr. Byrne. Ms. Bonamici, you are recognized.
Thank you very much, Madam Chair, and thank you to each of the witnesses for being here today. And I want to reiterate the importance of small businesses to our economy. My mom was a small business owner. My first job was in a small business, and we all appreciate the role that small businesses play. And Mr. Reese, I want to mention that we don't have Dat Dog in Oregon yet, but I saw in your testimony you have vegan and vegetarian options, which would be very popular in Portland, Oregon, so I assure you of that. We've had this conversation many times in this committee, and some of you who have been here know that years ago I did practice law. And I respect Mr. Byrne for his comments. I represented franchisees in disputes with franchisors, and I represented many franchisees over the years. And so I'm quite familiar with this debate and this dispute. And I wanted to really follow up. Ms. Ruckelhaus, your testimony noted that there really aren't cases where the franchisor has been liable along with its franchisee. We know the facts of the Browning-Ferris case. We've talked about that a lot. They did retain control. Freshie did not. And we all agree that we need to have clear statutes. That's not the issue. We want statutory clarity. But this is not a one-size-fits-all situation. And a case-by-case basis, I mean, a fact-based decision is really, I think, what we're talking about. It wouldn't, and I'm going to ask you, Ms. Ruckelhaus, wouldn't the remedy be for the franchisor to simply limit the extent of its control over employment matters? And when you look at the Freshie case, I mean, that's what happened. If the franchisor is involved in the essential terms and conditions of employment and retains control over that, that franchisor is acting like an employer. But limiting the extent of control over employment matters would mean they're not. So could you expand on that a little bit and why? I mean, I agree. This is not with my colleagues who said this is not, in your testimony, this is not a threat to all franchises.
No, I mean, I agree. And I actually think that it's not a question so much of limiting the franchisor's control over the franchisee. It's if the franchisor decides to contract and engage with a franchisee, both parties want there to be compliance, worker protection standards, and all the business brand protections that are available in those relationships. And so if they work together, as it sounds like Mr. Reese is doing with his startups, there shouldn't be any violations. There won't be any discussion about, are you an employer or an I'm an employer? Who's responsible? You have above-board contracting and franchising arrangements. Right. It's only when something goes wrong that you need to look at, did somebody come in here and prohibit the franchisee from complying with the law? And that's really what was happening with Browning-Ferris. The staffing company was not able to sit down and fully bargain with the workers because it didn't call the shots enough. And so it's going to depend on the situation. One size fits all doesn't matter. Another really important policy in our labor and employment laws is that labels don't matter. So if you give someone a franchise label, that shouldn't absolve them of responsibility. You need to look at the relationship and see if there is a exercise of control or not.
And to follow up on that, Ms. Thompson testified that franchisors are cutting back on giving training to technicians, helping franchisees find new employees, and providing point-of-sale software to franchises. In your view, is providing training a matter that implicates franchisors as a joint employer? Is providing resume referral service a matter that implicates franchisors as joint employers?
It's not. And I wouldn't take that case. I'm a practitioner. I bring lawsuits for workers. I would not take that joint employment case. Training is not listed as, at least under the Fair Labor Standards Act, and I think it's a multi-factor test, but training does not implicate joint employer status. It can in the broader totality of the circumstances that courts look at, but it's not by itself going to create a joint employment relationship.
Well, thank you very much, and I yield back the balance of my time.
Thank you, Ms. Bonamici. Mr. Allen, you're recognized for 5 minutes.
Thank you, Chairman, and thank you for participating today. Obviously, from the business standpoint, at least in my industry, the construction industry, in our subcontractual relationships, we have both union and non-union subcontractors, and we handle that on the same job site, maybe using 2 different gates or whatever, and accommodating. And of course, the manpower industry is growing at a very rapid rate in this country, and many of these manpower companies operate both open shop and union. So we've got to come to some solution on this problem. And Mr. King, it's been suggested that indemnification clauses in contracts can protect franchisors and contracting companies from liability the actions of franchisors and contractors. Would you like to comment on that?
Yes, Congressman. First, I'd like to identify with remarks Mrs. Thompson made on that point. It's not practical. In fact, I spent 25 years advising employers in these matters. I remember one day suggesting that approach because of the way the law was evolving in this area, bringing in business entities to court when we didn't need and shouldn't be there. And that general counsel turned to me and said, "This makes no sense. I have hundreds of prime subcontractors and hundreds more of subcontractors. I don't even know who all those people are. You're going to ask me to go forward for months and months to negotiate indemnification clauses? And furthermore, Mr. King, couldn't those negotiations in and of themselves be used as an indicia of control to be used against us to be found to be a joint employer?" And he finally said, "Why are we having this conversation at all? Because my company shouldn't be at the end of these lawsuits. We shouldn't be subject to this type of litigation." So it's not a practical solution.
What is a practical solution?
To bring some clarity to this area of the law. Now, I've heard this one size fits all, and that's the mantra, apparently. That's not what we're suggesting. A statute, Mr. Burns is absolutely correct. A statute passed by this body, not some administrative law institute or some court, a statute passed by this body can provide flexibility, it can list a multiplicity of factors, and can give guidance to the courts and the regulatory bodies. You tell me that a 15-factor test used by the EEOC gives clarity to anything. Absolutely not. So the answer to your question is, this body can and should provide clarity in this area and can do so by incorporating definitions from the common law. I keep hearing common law all morning. That's fine. We can take those definitions and put them in a statute. The responsibility belongs with this body, not somebody else.
Thank you very much for your input there. Mr. Reese, why is a company like DatDog more at risk from an expanding joint employer standard than larger multinational chains?
Can you repeat the question? I'm sorry?
Yes, sir. Why would your company be more at risk from an expanding joint employer standard than, say, larger multinational chains that...
Exactly what you said, the size. I can't weather that storm,
right,
like some of these other companies can. Right. I'm still hoping, you know, our business does
Hoping
well.
to be a multinational one.
Hoping to
right.
get there.
Yeah.
And if we don't get there, you know, it will be because we're stagnant and we're not growing because of this standard.
Yeah, and we're seeing that in the regulatory process. I mean, it's killing the small business community in this country. And just like this stuff, trying to clarify this, and I mean, it's just, you know, you can only throw so much at us that we can overcome, particularly on, you know, economy that's not growing in difficult margins. Mrs. Thompson, you were once a franchisee and now work on the other side as a franchisor. What are the benefits of buying a franchise instead of opening an independent business?
Probably the best thing is the system. It's a blueprint or a recipe for how you succeed in that particular business. When I started as a franchisee, they taught me everything from how to read a profit and loss statement to how to bake the cookies to how to run my business. And I can honestly say I would not be sitting here today having been a successful business person if my franchisor had not provided the systems to me so that I had that I could ramp up in business quicker. I didn't come in with a lot of money. You can imagine the Marine Corps didn't pay me a lot of money through my service.
And this model has created more small businesses in this country than anything.
Yes, sir. It certainly has.
And what we're talking about today has a tremendous impact on the growth of that industry.
I wouldn't be sitting here today if I weren't so passionate and so worried about where we're heading.
I've got a few seconds. Small business generates 70% of all job growth, and we've got to fix it. Thank you.
Thank you. Mr. Norcross, you're recognized for 5 minutes.
Thank you, Madam Chairwoman, and certainly witnesses for coming here today with your testimony. And I agree with Mr. King in his call for bipartisanship. I certainly stand here ready to work with our colleagues on the other side of the aisle. But today we're looking at employers have increasingly moved away from direct hiring. We see this time and time again. Leased employees, subcontractors, permit temps. Approximately 3 million Americans are now employed by temporary staffing firms. In terms of growth, about 1/5 of all new jobs are through temp agencies. So the question today, in many ways, is the goal of a joint employer and the law is to guarantee freedom of employers to insulate themselves from legal responsibility to workers while maintaining control of the workplace. So we're focused on two primary issues here when it comes to joint employer definition. One, the Fair Labor Standards Act, and then the Occupational Safety and Health Act. I want to focus on worker safety and OSHA. And there's a fundamental problem here today for the American worker. When an employer, whether a franchisee or franchisor, cares more about their hot dogs than they do worker safety. Yeah. More concern for control over the brand than over the worker. There was a documentary in 2015 called A Day's Work. Young man hired by a temp firm in Bacardi down in Florida was on the job 90 minutes before he was crushed in a machine because he had zero safety training. Lockout, tagout procedures. That means you lock the machine out so you don't get crushed by it. This is a fundamental issue that we all should be caring more about worker safety. So the person that goes to work in the morning can go home to their family in the afternoon. I've been on 3 jobs where that didn't happen. I never want to look another family member in the eye and say, your husband was killed on the job. Joint employer means we're all responsible for people's safety. So when we talk about safety, Mr. Harper, why is this important for the average worker on a temp firm?
Well, my concern here is that not that legislation, any legislation is passed. My concern is that a legislation that departs from the common law, that retracts the scope of the protections for American workers. Fair Labor Standards Act, the National Labor Relations Act, expanded it from the common law. But if this body retracts it in a way that makes it impossible for the worker harmed on the job to find, as in Ms. Ruckelshaus' example, to find a responsible employer, this Congress, by that legislation, would be harming American workers rather than helping them. Let me just say, can I say a little bit more?
Quickly.
Quickly. I understand that the franchisor community has been affected by this uncertainty. When I say this is a tempest in a teapot, I say that they've been affected because the lobbyists and lawyers have told them there's a problem, and they're giving bad advice because BFI does not say training or brand quality control can lead to joint employment. And if it does say that, the courts will rebuff it because the common law does not allow that. That's why I say this is a tempest in a teapot. I know they're concerned. They've been whipped up by their lawyers. But that is bad legal advice.
We hear you, and thank you for your input on this. I think growing jobs, growing the economy for opportunities for workers and employers is our ultimate goal. But when it comes to worker safety, I don't care if it's a franchisee or franchisor, we're all in this together. I don't think there's a person out at that table that doesn't care about the employee, whether it's you or somebody else. Getting killed on the job is something that we can't do. So in many ways, we're looking at two different issues here. Ms. Rucklehouse, when it comes to safety, if what is being proposed comes into fruition, does that in fact make workers, whether they're an employee of a franchisee or a franchisor, less safe because they'll back away from those safety issues?
Yes, I mean, your example of that horrible case of the worker getting crushed is a good example. The staffing company didn't take responsibility, and neither did the worksite company, and the worker fell through the cracks, and he literally died. There are other examples in addition to the auto parts workers I gave in Canton, Mississippi. There are hospital workers who are brought in to do housekeeping in hospitals. If they're brought in by a staffing company, they're exposed to bloodborne pathogens and needle sticks. If the hospital thinks it doesn't have to train them or take care of them, and the staffing company doesn't either, they could get exposed to HIV and other bloodborne pathogens. It's a serious problem, and we don't want the workers to fall through the cracks.
Ms. Ruckelshaus.
Thank you.
Thank you, Mr. Norcross. Mr. Grothman, you're recognized for 5 minutes.
Okay, just in general, I think the reason there's more use of staffing companies is because we make it more and more difficult to be an employer in your own right. But first question I have is for, say, Mr. King, Mr. Heiser. Under the joint employer standard, I think one of the joys of owning a business is the freedom to say I'm my own boss. If this is continued to allow to stand, does this make you more or less free from the franchisee? In other words, are you more like my own boss or not?
Please, go ahead.
FedEx does not have any franchises, but one thing I would offer is that this is an area which is completely uncertain, which brings unpredictability to businesses. And you don't have to look any further than the Fourth Circuit, who said that courts have failed to develop a coherent test for joint employment.
Okay, maybe I'll go to Mr. Reese. Does this joint employer standard, does it give you more or less freedom? Are you more or less your own boss, whether it exists or not?
You are, with this uncertainty, you have less freedom, in my opinion. And before this committee, over the last 2 years, you've had 10 franchisees, not franchisors, but franchisees, talk about this standard and how it is negatively affecting them and their ability to own their own business.
Okay. Good.
If
Sorry
I'm
to go quickly on that.
May I also respond, Congressman?
Sure.
Let me give you an example. It's in our testimony. You know, this is a large business. So I want to just say this for the record. We, from a large business perspective, fully adopt the concerns of our small business brethren and franchisors, franchisees. But this is a problem for big business, too. That said, your question's an excellent one, because one of our member companies required of its supplier to furnish to the supplier's employees a minimum number of sick days, socially desirable. This company, in fact, had been invited to the Obama White House and had been praised for its social responsibility. As a result of that good deed, the NLRB turns around and finds it to be a joint employer. Freedom? No. Why don't we have more freedom for employers to offer benefits? I'm sorry the congressman that just asked the safety questions is still not here. Training should have been provided for those employees. We certainly support that. But as we give more training, as we help our supplier workers more, then we get tagged out of being a joint employer. This makes no sense.
Okay, next question I have in general is standard. Does it make, I think one thing that's a problem for all businesses, in addition to doing what you want to do, you know, whatever your business is, retail, restaurant, whatever, you've got to worry about other laws. Does this make your life more or less complicated? Or I'll put it another way. Does this standard make it more or less likely you will be paying bills to lawyers?
More likely.
More likely, okay.
More likely.
More likely.
Congressman, I can tell you, I was in private practice, as I mentioned, for 25 years. This type of question started to reoccur and reoccur. Here we are spending these thousands and thousands of dollars on law firms, frankly, that could and should be spent on job creation, on better benefits, better pay, et cetera. This is a waste of our national resources.
Right. You wonder why our standard of living isn't higher. You've got this huge albatross, this sea of lawyers out there that our society has to pay for. And you're saying this is the type of thing that more lawyers. Okay. Next question I have for you. I know every business wants to operate efficiently, and I'm not going to talk about wages. I'm just saying as far as efficiency. Is this going to maybe dig into the efficiency of franchisees, which ultimately will drive up the cost of everything?
Yes, it will dig into the efficiency just using the job descriptions. Our franchisees wanted to get those job descriptions faster, and it took us months and months longer than what they were waiting for.
Okay, everybody agree with that? Final question is, I think it's good if we have more businesses, particularly small businesses, and a lot of times franchise it results in more small business, which is a good thing. I wish we had more small business in America. I think it's kind of a shame that over time you get all these multinational things. What effect will this have on the ability for more small businesses to open up? More or less? Make it tougher to start on the ground floor and open up a restaurant or open up a packaging company or whatever?
It'll make it tougher because there is no permanent clarity. There is no blueprint to starting the business in the right way, franchised or not. We want to comply with the law as a small business.
Thanks much. Less small business, more lawyers.
Thanks, Mr. Grothman. Ms. Adams, you're now recognized for 5 minutes.
Thank you, Madam Chair, and thank you all for being here for your testimony. Ms. Ruckelshaus, Mr. King's testimony criticizes the way that joint employer decisions under the FLSA have evolved in federal courts and proposes a one-size-fits-all standard. Why is FLSA's fact-specific analysis important in determining whether an employment structure constitutes joint employment?
Yes, thank you for that question. The one-size-fits-all labeling does not work because there's too many different kinds of jobs, too many different kinds of arrangements that the companies decide to set up. It's no longer common for one company to simply have its employees. Businesses are making lots of decisions today to outsource parts of their business, and so our statutes were actually enacted with some of these structures in mind. When the Fair Labor Standards Act was enacted in 1934, garment sweatshops were around. So the Congress knew that there were subcontracting, different structures, so we need to have these fact-based tests to look at each relationship and see, do you need to have more than one responsible employer or not?
Okay. So why would it be disadvantaged for workers to be one joint employer standard for all of the labor statutes at issue today?
Well, the labor statutes address different problems. The Fair Labor Standards Act started out looking at child labor, which was a huge problem in our country when it was passed. So it has a much broader standard of who's responsible to make sure that child labor and minimum wage and overtime are paid. Whereas the National Labor Relations Act has a different set of policies behind it to ensure that workers who want to come together can come together collectively to bargain, and that they're protected when they do come together and ask about working conditions.
Thank you. The Fourth Circuit Court of Appeals, which has jurisdiction over my state of North Carolina, recently decided in favor of the joint employment standard, employer standard in the Salinas case. Critics of the case have stated that the case expands the standard under FLSA in a way that is incredibly broad and will prove unworkable for employers. Can you explain how that case fits in with longstanding precedent under the FLSA?
Yes, and actually we had a brief in that case. These are residential drywall workers who worked in Maryland. Their direct employer disappeared. The court said it was defunct. They weren't paid properly, so they brought a claim against the general contractor. The Fourth Circuit had never developed a joint employer standard under the Fair Labor Standards Act, and this is this year. So again, there aren't that many of these cases, but when you do have them, and you have a case like this where residential worker and construction workers weren't able to get paid, you need to have a joint employer relationship. The court took long-standing cases from the 1940s to develop its standard, and it's completely well within the bounds of the statute.
Great. Thank you. Thank you very much for your responses. I yield back, Madam Chair.
Thank you, Ms. Adams. Mr. Lewis, you're recognized.
Thank you, Madam Chair. We had a colleague not long ago suggest that one witness might be more interested in his hot dogs than in the safety of his franchise workers, and I think that's just a little bit insulting, and I just want to make certain that Mr. Reese gets the opportunity to respond to that if he so wishes.
Yes, absolutely. And in my testimony, I said the most important thing about our restaurant is our people. That's why we're here today. That's why we want to franchise our business. I love our food options, I really do. But the mentorship work that we do with Son of a Saint, the things that we host at our restaurants are much more important than the food. And so absolutely, 100%, we love our employees. You know, we want to employ our employees, but if somebody comes to me to buy a license to operate their own business, those are not our direct employees. And that's what we're talking about here today.
Okay, I just wanted to give you the opportunity
Thank
to do
you.
that. Mr. Heiser, and perhaps Mr. King as well, BFI came out of a temporary labor service agreement, but I want to expand the discussion with regard to the non-franchisee or franchisor relationship. I grew up in a family business, and we were warehouse distributors. And the traditional non-franchise channels of distribution, you'd have warehouse distributor, then a jobber, then an end user, or actually then a retailer, then an end user. And I'm looking at this test that came out of BFI, and it calls on the ability to exercise potential, indirect, or reserve control. And the vagueness of that test makes me wonder whether or not this thing doesn't have a little mission creep in it and goes far beyond franchisor or franchisee relationships into non-franchise relationships and into the traditional standards or channels of distribution from wholesalers like the business I grew up in.
Please.
I would say just quite simply that Browning Ferris introduced the concept of reserve control, indirect control, and that just creates uncertainty in any business relationship.
Mr. King, would, for instance, agreements, if you're a warehouse distributor or wholesaler, agreements with the manufacturer with regard to inventory levels, inventory management, price maintenance perhaps, volume discounts, would that be indirect control?
It certainly could, and your question, Mr. Lewis, is an excellent one. If I could go to the Fourth Circuit, which was just mentioned by Congressman Adams, this recent decision out of the Fourth Circuit creates yet another test. And let me just read part of this Fourth Circuit decision because it's directly to your question. The Fourth Circuit finds a joint employer relationship, and I quote, "An entity may be deemed a joint employer if it merely plays a role in establishing the key terms and conditions of the worker's employment." Well, what's play a role mean? But per your question, and all due respect to this discussion we're having here today, why can't we, as intelligent people, take the common law, put it in a statute, and bring some sanity to this area? Your industry is a perfect example.
I think one witness said, well, look, if you're ordering the captains and the privates to do this or that, but aren't these agreements something we used to call in the common law contracts? And if every single contract becomes all of a sudden control or indirect control, then you affect all sorts of business relationships.
Well, you're absolutely right. And what's wrong with part of our state of the law today, Congressman Lewis, is that we have these statutes that were passed decades ago. They haven't kept up with the change in the modern workplace. Whether we like it or not, we're going to have more people working off the platform, more working in an independent relationship, whatever you may call it. So our statutes and our regulations are simply out of date. And this isn't a big step to take, frankly. As I mentioned, this could be a nonpartisan, bipartisan approach here of simply drafting some language to incorporate, as the professor mentions, common law. One last thing, if I may. There's been the suggestion in the hearing today that somehow the Fair Labor Standards Act cases are so different than the common law, so much more liberal. I want to quote the professor's testimony on page 6 over to page 7. Quote, in my research as an ALI reporter, I find no sharp distinction between the FLSA cases and common law cases. So from our own expert from the ALI, this is a non-issue. Back to your point,
quickly,
we're in a situation where we need some clarity.
All right, very good. I thank the witnesses and I yield back.
Thank you very much, Mr. Lewis. Mr. Takano, you're recognized for 5 minutes.
Thank you, Madam Chair. I appreciate the in-depth analysis of the various joint employment standards in the written testimony, but I think we're getting bogged down into whether there's all this uncertainty or whether there is a kind of sponsored uncertainty or a fostered uncertainty out there. And so we're talking about a standard that is in place to ensure that employers are accountable under law and can't deny employees their wage and rights through statutory loopholes. Under the Fair Labor Standards Act, this means making sure workers get their legally guaranteed overtime and minimum wage. Now, it's my understanding that the FSLA standard of joint employment is not new, and it hasn't really changed. There's all this talk about uncertainty. And I'm hearing from Mr. Harper that it's manufactured uncertainty, which is making, I don't want to belittle any of the franchisees here, but that the franchisees have been made to be afraid and have been made to hire lawyer up unnecessarily. So is it true that the standard of joint employment is not new and it hasn't really changed? Is that correct, Ms. Ruckelshaus?
Yes, the statute's been on the books since 1938 under the Fair Labor Standards Act. I actually disagree with Mr. Harper's conclusion that it's not much different than the common law, than the NLRA. It's a very broad standard of who's responsible as an employer. The statute uses the term suffer or permit to work. That's incredibly broad. And it hasn't changed. There's Supreme Court cases from the 40s that laid out the standard, and that's been the standard since then. There's nothing new for the Fair Labor Standards Act.
Mr. Harper, you care to comment?
Well, the Supreme Court definitely has said that it's broader than the common law definition. There's no question about that. And because they have stated that, the lower courts have come up with different factors they call an economic realities test. Under my research, I think that they're really getting at the same thing that the common law gets at. That's why I took that position.
Okay, all right. So I want to highlight what's at stake if we don't have a functioning joint employer standard. In 2015, the Wage and Hour Division found that J&J Snack Foods, a leading manufacturer of popular foods and beverages, was a joint employer with its staffing firm and failed to pay its workers minimum wage and overtime. J&J had to pay over $2 million in back wages to 677 workers. In the J&J case, workers were owed 5 weeks of back pay, 5 weeks. And in some cases, workers were owed nearly 8 weeks of earnings. A recent survey from the Federal Reserve found that 46% of Americans said they didn't have enough money to cover a $400 emergency expense. How could they possibly afford missing nearly 2 months of earnings? Ms. Ruckelshaus, is this type of violation in J&J Snacks common or uncommon?
Unfortunately for low-wage industries, and the ones I mentioned in my testimony, like janitorial, home care, retail, restaurants, where there is subcontracting or use of temp and staffing firms, workers' wages suffer and wage theft persists. And oftentimes the wage theft piece of it is because neither of the employers is taking responsibility for ensuring minimum wage and overtime. So it is a problem, and it does get exacerbated when there's outsourcing or subcontracting.
Well, thank you. Mr. Harper and Ms. Ruckelshaus, if you both have time, we'll go to Ms. Harper first. What would be the impact on workers if there was legislation presented narrowing the joint employer standard under the FSLA?
Well, I think, number one, under the FLSA, it particularly have an impact where you have a thinly capitalized business, where Ms. Ruckelshaus mentioned the garment industry. There are a lot of cases out of that where there's hardly any capitalization, and the workers are not paid adequately their minimum wage. They can't sue someone or a business that's insolvent. It's particularly important in those cases where you have thin capitalization, it seems to me.
And thin capitalization, in layman's terms, is just the company doesn't have enough money.
Yeah, there's not enough money to pay them.
And the workers don't
get
any.
Right, and we're not talking again about the typical franchisor thing. That's not what we're talking about here. We're talking about where the Fair Labor Standards Act, the joint employment, is really important, is where the workers don't have any business that they can, any employer where they can secure their rights. And my main concern here is that legislation is drafted in a way to take that away from the worker.
Well, thank you. I'm out of time. I yield back. I wish we could have had your testimony as well. Sorry.
Thank you, Mr. Takano. Mr. Smucker, you're recognized for 5 minutes.
Thank you, Madam Chairwoman. I'll direct this question to Mr. Reese and Ms. Thompson. Strengthening career and technical education, expanding apprenticeship opportunities, as you've heard, are top priorities of the committee and top priorities of mine. I believe it's critical to help fill the skills gap that we're currently facing in our nation. As you know, the President recently proposed an initiative to build up more apprenticeships in the private sector. You mentioned that some of your franchisees and franchises are already doing some of this, and that employees can participate in apprenticeship-like opportunities in your companies. Can you elaborate on these opportunities and explain how the joint employer definition has prevented or interrupted your ability to continue offering these types of programs to employees?
Thank you, Congressman Smucker. We are in the trades, and apprenticeship programs are critically important because right now the trades are at an all-time low for people who can do the work. The millennials don't know how to do the work, and the millennials' parents don't want to do the work. And so we are having to help our franchisees home grow those technicians and home service providers. And so we have a number of programs. I mentioned earlier Rainbow International, which is our restoration brand, has a good program where they not only train how to do the type of restoration work, but they provide certifications that give those apprentices an opportunity to grow within their field. And what's happening now is we're spending a lot of time and money reconsidering those programs because of the uncertainty of what's come from Browning-Ferris. It's causing us a lot of consternation and more time than it should be, and it's keeping us from growing our business.
Thank you. Mr. Reese?
We don't have any apprenticeship programs at this time. We're implementing programs with high schools in our area. The summer before college, right after high school, we want to hire in a couple of seniors so that they can go to college with some money in their pocket that they may not otherwise get, and teach them about franchising as well. But we have kind of pressed the pause button on putting that program into place, and I think the joint employer standard is one of the main reasons why.
Thank you. I'm going to jump back. I was a business owner as well, and it was a contracting company. We were a wall and ceiling company where we both contracted with a general contractor, but then we also would contract with other individuals who provided services to us as well. So maybe, Mr. King, this may be a question for you. I really have some concerns with the Fourth Circuit Court of Appeals decision that would expand joint employer beyond the Browning-Ferris case. We know it applies only there at this point, but do you think other courts are likely to adopt the same position? And if so, how will these standards further implicate companies that are already making tough decisions and changing their business models under the stress of joint employer?
Thank you, Congressman. First, this is a Fair Labor Standards Act case, so it does start to change the law if it holds. Second, certainly the district courts within the Fourth Circuit will be bound to follow this decision unless or until the Supreme Court accepts this case for review and overturns it. Beyond that, this plants the seed again for additional litigation. If I'm a plaintiff's attorney, I read the Fourth Circuit decision, I have a new theory to take to the Ninth Circuit, the Eighth Circuit, or the Sixth Circuit. What, again, the opponents of our position are missing is the litigation is evolving here to a higher degree than it's been in the past. So why can't we stop that and bring some clarity? So your question's an excellent one. The Fourth Circuit decision is going to create more problems for small and large employers and going to cost us more money in defense costs and have more litigation expense to deal with.
Do we have data on the economic and employee impact if that decision were expanded?
I've not seen any yet, Congressman, but that's being worked on because, as I mentioned, there are petitions for certiorari that were just filed. And if the court accepts this case, there's going to be a lot of documentation, a lot of research done to support the position that the Fourth Circuit simply is not in touch with reality. As I mentioned a moment ago, this new Fourth Circuit decision holds that if an employer just plays a role in setting the terms and conditions of employment, it can be a joint employer. What does that mean?
Thank you, and I'm almost out of time, but as that moves along, if there is additional information that becomes available in terms of the impact, I'm certain the committee would certainly love to have that information.
Thank you, Congressman. We will do that. In fact, we have filed today with the committee the amicus brief that the HR Policy Association, the U.S. Chamber, the National Association of Manufacturers, American Retail Federation, and RELA all filed with the Supreme Court. So we will certainly keep the committee abreast of what we are doing.
Thank you.
Thank you both very much. Mr. Rooney, you're recognized.
Thank you, Madam Chairman. I'd like to continue along the line of my fellow construction guy, Lloyd, and ask Mr. King. You know, construction is a major contributor to the U.S. economy with over 6 million employees and 650,000 employers, 2 of which are me and Lloyd. It creates over $1 trillion worth of buildings every year and expends 2.9% on employment, and it's built on subcontractors. The industry cannot live without subcontractors. Even when you do a lot of self-perform, which our company does, it's still only 20-30% of a job, maybe 40 on a bridge. And so as you say in your testimony, employers are increasingly left in a quandary as to their status after BFI. And you also say that there's risk of expansion of BFI, especially in the FLSA and OSHA areas, which are also absolutely intermingled in construction. So my question for you is, I have this nightmare of one of our job sites with a ready-mix supplier with off-site batch plants. And they have an OSHA problem or an FLSA overtime problem or, God forbid, a hazmat problem on those batch plants. Imagine holding a contractor liable for CEMEX's batch plant, which could be 20 miles away. What do you think about that?
It's a legal problem. It's a practical problem. And let me expand. First, what we all need to realize here is we're dealing with a very powerful legal doctrine. The joint employer doctrine is a doctrine that says a non-actor, such as the general contractor in your example, that wasn't involved in any way, shape, or form the incidents or omissions in question that you mentioned, had absolutely no knowledge of them, certainly didn't ratify them, had no contact with them, can be held jointly liable. That is a tremendously powerful legal doctrine. And per your question, the general contractor only ought to be held liable from our perspective if there is significant control over those subcontractors that had the violations. I'm glad you asked this question because while we certainly agree from the HR policy perspective that franchisor-franchisee relationships are important, the committee needs to look at construction. The committee needs to look at a lot of other industries where this joint employer problem is prevalent. And as I mentioned just a moment ago, it's also a problem for the large employers in this country. So we have a very difficult and challenging legal issue that can and should be addressed.
I really appreciate that answer, and I'd like to ask you one more follow-up. I still have a couple of minutes. It's even more scary with your answer because a general contractor has to exercise significant control over his contractors to comply with the AIA and the American Society of Civil Engineers, respectively, for buildings and bridges contract documents. We have to have fitness for duty clauses that deal with dress, steel-toed shoes, and OSHA compliance. We have very strong language about overtime, FLSA, especially on government jobs paying bonded payrolls. We have to have strong language controlling their schedule to get them to adhere to what we commit to the owner. And lastly, we have very strong QC/QA provisions that stem from the Corps of Engineers back in the 60s. So you add all that up there, we're de facto Browning-Ferris slaves.
And also under the Fourth Circuit, Congressman, the decision you just mentioned, you are in a situation where you may have potential liability for all of the actions and omissions of all the subcontractors because of the regulatory and statutory requirements. Back to this discussion we had a few moments ago about safety. We all in this panel would agree that safety is important in the workplace, but let's permit the general contractor or the host employer or the franchisor to provide safety training. Let's encourage that to occur, but not take that action as an indicia of joint employer status. We're hurting everybody by the state of the law that we're in today.
Once again, I got 30 seconds left. You knocked it out of the park with that answer, too. We used to have what we call the voluntary inspection program with OSHA, where OSHA would come on a job site, work with management, work with the superintendents, and make sure that we were working as safely as we could be in a constructive partnership. As soon as Obama came in, it just became send in the lawyers. No cooperation, no positive reinforcement, no nothing. And I think you hit the nail on the head there, and I really appreciate your answers today, Mr. King.
Thank you.
Thank you. I yield.
Thank you very much, Mr. Rooney. Seeing no further members to ask questions, I'll recognize the ranking member for his closing remarks.
Thank you, Madam Chair, and I thank the witnesses for your testimony. It's been alluded to that the joint employment question only comes up when there's a violation of the law. That is, some employee's been cheated out of overtime, or there's an OSHA violation, or the violation of labor law because an employer fails to negotiate. Then the question is whether or not there's a joint employment situation, basically trying to find out who did it and who's going to be responsible for the violation. You may have caused, for example, a Fair Labor Standards violation, may have caused it by setting wages that are under overtime or require people to be misclassified or some other violation, but that doesn't make you responsible for an OSHA violation. You wouldn't be found a joint employer for the terms of an OSHA violation you didn't have anything to do with. As Mr. Harper has indicated, the law we've been working on, common law, has been generated in terms interpreted over decades. If you make a new statute, you'd have to start from scratch interpreting those laws. So you don't make things any more or less clear by passing a statute. If the goal is to free franchisees from control over a franchisor, immunizing the franchisor from responsibility would just encourage the franchisor to exercise more control. And if you have you have the added responsibility, as it's been suggested, that if you have a temp agency or a franchisor, if there's a violation, they probably are not capitalized enough to be able to be responsible for what both actually contributed to. And so, again, I don't think there's a question of lack of clarity. If the goal is to have franchisors with no responsibility, that's one thing. But I think the law is clear that if you helped make the problem, you created the violation, then you ought to be responsible. And that's what the joint employer standard does. With that, I yield back.
Thank you, Mr. Scott. I want to thank our witnesses again for being here today and providing a great deal of enlightenment, I believe, on this issue that we are discussing on joint employment. It is something that has been talked about and written about a great deal ever since the first actions came out of the NLRB in this respect. Someone said here that it sounded like some people are living in an alternative universe. And as I sat here today and listened to the testimony, to the questions, to the comments, I am really struck by thinking I would get an 8-ounce glass of water and put it up here with 4 ounces in it and say, some people see this as half empty, some people see it as half full. I mean, it truly is a very different point of view on this issue. I want to associate myself with the comments Mr. Byrne made when he made his comments about the need for us to have legislation. And I go back always to the Constitution. When I taught a lot and even talking to people, I always say go back to the original documentation. I think the situation with joint employer, the various rulings that we're getting out of the courts, the various interpretations of the ruling itself is an indication that there are problems out there. Real problems. When I'm in my district and I talk to employers, what I hear all the time is, we need some certainty out of Washington. It comes from every kind of employer, every kind, whether it's taxes, rules and regulations. Employers are desperate for certainty. As I said in my opening comments, was a small business person for many, many years. My husband and I ran a very small business. And so I understand, I think, where most small business people are coming from. And I don't know a bad employer. I'm sure there are some out there, but I sure don't run into them. And I hear horror stories all the time from the other side. But the employers I know care about their workers, want their workers to be safe, want everybody to succeed, because when one of us succeeds, we all succeed. And so we really do have totally different points of view on many of these issues. I think a lot of it has to do with lack of experience in the private sector by some of our friends and some of our witnesses, that there's absolutely no experience in the private sector, and somehow or another, opinions have been formed maybe off of one bad person. I'm not sure. But as I said, I always go back to the original document, which is our Constitution. And you know, it doesn't start out with we the courts. It says we the people. And I also point out constantly, Article 1, which outlines the roles and responsibilities of the legislative branch, has 2,312 words in it. It gives us a lot of responsibility. Article 2, the executive branch, 1,031 words. Article 3, the judicial branch, 379 words. The founders did not intend the courts to run this country. The founders intended the people's body to run this country. And to suggest that we need to leave all of this up to the courts is, I think, totally out of touch. The people of this country want us to take our responsibility. We're called the People's House for good reason. The Senate is the Senate, but the legislative branch is where the responsibilities are for the laws and for the guidance of the people. And so I think we have a huge responsibility in this area and in a lot of others. The last administration, if it's ever going to be known for anything, I think it's going to be known for the conflictions it has created in the law and in the regulations. Time after time after time, we're here trying to clean up the messes created by conflicting rules and regulations. That is our responsibility here in the People's House. And I'm going to do everything that I can to make the language as clear and as plain as possible in legislation and not rely on the courts. So thank you all again very much for being here. It's been a very interesting session. And
Chair?
Yes, sir.
Madam Chair, it's unanimous consent that a letter from the law firm representing the Teamsters Local 350, which represents the BFI and its staffing agency, be entered into the record.
Without objection, this hearing is adjourned.